I want to talk about a topic that comes up very, very often in our practice. We literally deal with this issue every day, and I think it's extremely important to inform our listeners, our clients, our contacts, the public at large about this topic. And that is about the enforceability of termination provisions in an employment agreement. Now, it may seem like a strange topic, and I may not understand what it means. So let me break it down. Let me explain to you what we're going to be talking about today. In an employment agreement, job offer letter, employment contract, in that document, an employer will often include a term that tries to limit your future termination entitlements. A term that effectively says, if at some point down the road we let you go, we will give you a fraction, a small fraction of what you would otherwise be owed, a small fraction of your severance. So you may sign an agreement, not realizing that you've effectively already preemptively agreed to give up tens of thousands of dollars in the future. So then 3 years later, when you were let go and you realize, oh, now I am only going to get 3 weeks pay instead of maybe 6 months pay because I signed that employment agreement 3 weeks ago. So obviously that's an important topic. Now, the thing about it is, what you need to understand is, in many of these cases, those provisions are not enforceable. So you may lose your job and your employer says, hey, employee, remember when you signed that agreement, it limits your entitlements. And you may think, well, I guess I have no choice. It is what it is. I signed it. But in fact, it may actually not be enforceable. And as a result of that, you may still be owed your full severance. So that's what I'm going to be talking about today. I'm going to be talking about situations where you may think you gave up your severance entitlements, but you in fact did not. So remember, a written employment agreement usually benefits the employer. As an employee, you would rather not have an enforceable written employment agreement. All that means you would then have the full protection of the law, the full rights of the law. So I'm going to be listing a few situations where, even though you may have signed an agreement that limits your severance, it does not really do so. So that's why it's important to get legal advice, because you don't want to accept pennies on the dollar thinking that you have no choice when in fact you do. So let's talk about the first situation where the employment agreement in fact does not limit your entitlements or would be considered unenforceable. And that is a situation where the agreement was actually signed after employment has already started. For an employment agreement to be enforceable, it absolutely has to be signed before employment begins. So the way that works is there's a bargain, there's a deal. You get the job, and in return, you agree to be bound by the terms of the employment agreement. So there's that bargain. Well, what happens if you sign the employment agreement after you've already started working? Well, you sign the agreement, but you're not getting anything in return because you already have the job. So because of that, an employment agreement that is signed after employment starts usually is not enforceable. And the devil's in the details. You may have signed the agreement on the first day on the job. It's already not going to be enforceable, because by the time you step foot into the employer's offices, you're already an employee. So that agreement is not enforceable. If you signed it a week later, a month later, during lunch break on your first day, it's not enforceable. It would have to be signed before employment starts. Now, in some situations, you may have gotten, say, promoted, and then the employer says, we're going to promote you, and then we want you now to sign a new employment agreement. Well, in that situation, the employment agreement may be enforceable if you sign and then get a promotion, because you got something in return. You got the promotion. But if you've already started, you were promoted on Jan 1, and you signed the agreement on Jan 4, well, by then, the employment agreement is not enforceable because you had already started that new job. So it's very, very important. I cannot tell you how many times someone comes to us with an employment agreement saying, here's what my employer is saying. My employer is saying that this limits my severance. And I look at the dates and I find out, in fact, that it doesn't limit severance because it was signed after employment starts. So we have to be very, very careful about that. And remember, for those that didn't join us right at the beginning, you don't want, in most cases, the employment agreement to be enforceable. Because if it's not enforceable, you have full protections of the law. So that is a key here to understand, that if you sign the agreement before you start working, yes, it is enforceable. In most cases, if you signed it after, it's not. So first thing I do when I see an employment agreement, I look at the dates. I look to see when the start date is, and I look to see when it was signed. And so many times I see it signed after employment starts. So That's one way where a termination provision, something that tries to limit your severance entitlements, is not going to be enforceable. The second way it's not going to be enforceable is if it's not drafted properly. What our courts have said over the years is we don't like terms that limit a person's severance. We don't like it. We don't like things that make it difficult for you now to earn a living. We don't like things that could make it difficult for you to support your family. Therefore, employer, if you want to limit a person's severance entitlements, you have to do it in a very, very specific way. That provision has to be drafted in a certain way. It has to say certain things in a certain sequence. And if it doesn't do all those things, it's not enforceable. In our practice, every single day, we do see termination provisions that don't meet those criteria, that are not properly drafted. They don't say everything they're supposed to say. Sloppy drafting, mistakes. I'm going to say that 60% of the time, they're not properly drafted. And if they're not, if they don't meet those criteria, then guess what? They're not enforceable. There's at least 10, 12 ways where an improperly drafted termination provision may become unenforceable. And I'm not going to list those because it could get very technical and it's beyond the scope of our discussion today. But what you have to understand is that you may be looking at an agreement and you may have signed it before you started working, so it's otherwise enforceable. But because the specific provision that limits your severance is not properly drafted, that may make that provision unenforceable. And guess what? If it is unenforceable, that means you get your full severance, even though you've signed it, even though you agreed with it, even though they've tried to limit your severance. Because it's not properly drafted, it's unenforceable. Therefore, again, I know I almost sound like a broken record here, but you have to get some legal advice when you're let go, when you're looking at a termination provision, because one of the things we have to assess is whether that provision is enforceable. Employers are getting smarter. They're using these termination clauses now very often. If you're going to be offered a new job tomorrow, I'll give you a 90% chance that there's going to be something in that agreement that tries to limit your future severance. And I'm not talking limiting it to the tune of maybe it's going to cost me $1,000, $2,000. I'm talking to the tune of tens of thousands of dollars. And depending how long you work and your compensation level, it can even be in the hundreds of thousands of dollars. So that's why it's so important. If you did, well, first of all, it's important to try to negotiate these terms and try to remove them. But if you haven't done so, if you can negotiate, if you can't remove them, we have to deal with them on the back end if you do lose your job. And we want to make sure at that point, or at least determine whether it is enforceable. And as I said, in most cases, it's not. So such a good idea to make that call and get some legal advice. Now, let's move on to another way where a termination clause may become unenforceable. And by the way, if anyone has any questions today, feel free to type them in. I'll try to take them. But moving on to another way where a termination clause may become unenforceable, and that is if in the meantime your job changed. So what do I mean by that? Maybe you got a position 5 years ago as a marketing coordinator. You've now been promoted to a marketing manager. Maybe eventually you made it up to director of marketing. So now you're the director of marketing. Well, what happened to that agreement you signed 5 years ago when you got the job as marketing coordinator? Well, guess what? It's unenforceable. Why? Because that agreement was an agreement for a specific job. The job that you have now is a very different job. It's not the same job you have then. It's very different. Because of that, that agreement does not follow through. Again, that's a good thing because you're not going to be bound by the bad things in that agreement, specifically the termination clause, the terms that tries to limit your severance. So we call that a change in substratum. The definition doesn't really matter much. What it does mean is if your position changed significantly over time, it's quite possible and likely that that agreement that you signed initially, it's unenforceable. Now, it's not every change in your job that's going to make the agreement to be unenforceable. It does have to be a significant change. So if you were maybe got a $5,000 pay increase and maybe a bit more responsibility, that may not necessarily be enough of a change. But if you've been promoted to a much different position, your compensation level, responsibilities are at a different level than they were, then guess what? That agreement is unenforceable. So that is a very important thing to understand. You don't want to be bound by the terms of the agreement you signed 10 years ago if you can avoid it. The other thing we need to watch out for is a really, really smart employer will actually put something in the agreement that specifically says that this is going to continue to apply regardless of what position you have. So it specifically tries to address this issue by saying that even if we promote you a year, 5 years, 10 years down the road, this is still going to apply. Now, if your agreement does say that, well, then you're stuck with it, unfortunately. You're going to be bound by it. But in most cases, almost all cases, the agreement does not say that. Therefore, if your position does change over time, if you're now in a different role, you're not going to be bound by that agreement. And you have to understand that that's a good thing. Again, when we talk about not being bound by the terms of a written agreement, some people may get very nervous. Well, what do I mean I'm not bound? What do I mean it's not enforceable? What does that mean to my job? No, that is a good thing. You don't want that. If I could have it my way for employees, I would have all employees start a job on a handshake. That's it, maybe an email. Certainly I would not want an employment agreement, because all the employment agreement often and usually does is take away entitlements and protections that you would otherwise have, either eliminate those or give those to the employer. So we're talking about ways where, despite the fact that you signed an employment agreement that's not favorable, how it may ultimately not become enforceable. So as I said, one way was if your job has changed significantly since employment began when you signed the agreement. Very, very important to remember that you're not going to be bound by an agreement you signed for a different job years ago. Now, moving on to the next topic or next situation, I should say, where the employment agreement or the termination provision may become unenforceable, is when an employer alleges a termination for cause and there really isn't cause. So let me give you an example. The employee was late twice this week. The employer is very unhappy, and the employer says, you know what, employee, I'm so upset you were late twice. I'm going to let you go for cause because I'm that upset. I'm not going to pay you any severance. So the employer is alleging cause. Well, obviously, if you've listened to our shows before, if you've heard us speak before, you would know that that wouldn't be cause, right? Because being late a couple of times is not, or does not rise to the level of cause. Cause is the ultimate penalty. It's reserved for the worst offenders. So you may have done something wrong, even a few things wrong, but that may well not rise to the level of cause. So in my example, the employer that lets the employee go for cause after being late a couple of times would have wrongfully dismissed the employee. That would not be cause. So what does that mean to the termination clause? The employer may think, okay, I have cause to let you go, but if I'm wrong, I still have that other termination clause that applies in a termination without cause situation. Except no. What our courts have said is if an employer terminates someone for cause and it's then determined that there isn't cause really, that employer loses the ability to rely on that termination provision. Okay? So just by virtue of the employer saying, well, I think there's cause here, I'm letting you go. If that's wrong, they then can't rely on the provision that limits your entitlements. That's a good thing. And it's also a lesson for employers. Don't take the position that you have cause. Don't allege cause when you don't have all your ducks in a row, when you don't have your I's dotted and T's crossed. And if your employer alleges cause, they may get penalized in a sense by being able to lose the ability to rely on the termination clause, which again means you get your full entitlements. So, and don't be too trigger happy, employers, if you're upset to terminate someone for cause. We've talked about this before. We'll talk about this in the future again. Is you have to build up a case. You have to have progressive discipline. You have to have things written up. You have to give the employee an opportunity to improve and provide them with the help to do so. And if they still can't do it, then maybe you can terminate for cause. It's the death penalty. It's the worst punishment for the worst conduct. And in my view, most employers pull the trigger well before they should. And there could be significant repercussions for the employer, including losing the ability to rely on the termination clause. Now, what we've covered over the past 15 minutes or so have been ways in which employers can lose the ability to rely on a termination clause. Again, for those that haven't joined us, that is a good thing for the employee. Oftentimes, these termination clauses can be the difference between getting $2,000 worth of severance and $50,000 worth of severance. Let me give you an example here. Let's say we have an employee that's worked for a company for 2 years, plant manager, making $80,000 a year. That employee has a termination clause that limits their entitlements. Guess what? If that person is let go, they get 2 weeks pay. What if that employee does not have a term that limits their entitlements? Well, that employee could easily get 6 months pay. So the difference between 2 weeks and 6 months, and without the calculator, that delta, the difference could be $35,000, $40,000, something in that range. That's one employee after 2 years of employment. What do you think will happen if that same employee is going to be there for 5 years, 10 years, 20 years? That difference would be significant. At some point, it could be the difference between 2 months pay and 24 months pay. Can you imagine this provision in the contract costing you almost 2 years pay? That's what we're talking about here. It's a huge, huge, huge deal. Literally tens of thousands of dollars, maybe hundreds of thousands. That's why, number one, my best advice is if you sign an employment agreement, if you're not sure what it does it limit your entitlements, is it favorable, is it not, get some advice. Even out the playing field. Try to understand what it actually says. And then you could potentially negotiate those terms, and I can give you some thoughts and tips as to how to do that. Number one. Number two, if you didn't do that, or you can't do that, and you ended up signing that employment agreement in any event, don't assume that it's enforceable. Don't assume that the bad things that it does actually are enforceable. And as I've given you examples throughout this presentation today, it may not be. So that may mean you still have the full protection of the law. So even more motivation and more reason, if you lose your job, if you're staring at the severance package, if you don't know if it's good or not, if you don't know if your employment agreement limits you, you have to get legal advice. You don't want to find out later that you walked away from tens of thousands of dollars that you're owed, like so many of my clients or my prospective clients have done. I get calls all the time from people that heard me speak, heard me on the radio, and they say, Lior, can you help me? I was let go, but I've signed off on my severance package already. And unfortunately, in those situations, the answer is no, I can't help you. You've signed off, you've agreed. The time to get legal advice, the time to understand what your entitlements are, is when you first lose that job, before you sign anything. So hopefully you now have some thoughts as to when your employment agreement may not limit your entitlements, even though your employer may think that it does. Share that with people, let them know. Don't have anyone sign a severance package because they assume they don't have a choice. I can assure you, in the vast majority of cases, I'm going to say over 90% of the cases, there absolutely is a choice, a good choice, an easy one, which will allow you to get your full entitlements. So that is it for us today. Hopefully you've learned something. Feel free to contact me at any time, email, phone, owls, whatever it is that the kids do these days. Happy to talk. And again, happy holidays to all of you. Have a safe and relaxing time off with the family. And we will see you all in the new year. All the best to you.